Hey, what's going on, everybody? So it's pretty late. I should be getting ready for bed, but I'm feeling a little motivated, and I'm feeling like I want to neglect my responsibilities to make an R. Kelly video. And sometime back, Michelle Davis, one of the people who come to my page on on a regular basis, she actually sent me a link to this bail denial motion. She sent it to me some time ago. I want to say 2 or 3 weeks ago, but I was really busy. I'm still really busy, and I really just hadn't had time to get to it. So I really don't have time to do this either. But like I said, I'm feeling motivated, and I just need an escape from my other responsibilities. And I've decided to make this video, right? So I'm not going to go through every detail of this appeal. I'm just going to cover the highlights, right? So this bail motion or reply memorandum is in the Eastern District of New York, right? So this is going to be for the New York case. He also has a Chicago case, which he was denied bail, and we're not going to talk about that. Now, just to let you know, I did see the bail motion for the Chicago. I believe I have, and I thought about doing a video on it, but it was massive. I mean, you would literally have to take out probably a month, just to go through everything that was in that one appeal brief, right? So I was like, I'm just gonna let this go. And when I did look over it, nothing in it really jumped out that seemed like it was that would suggest that it should be covered. That's my own personal opinion. Now, of course, I'm not a lawyer, so there there more than likely is some very substantive parts in that uh, appellate brief, but it escapes me because I'm not a lawyer. I'm not trained to do this stuff, and I have little knowledge or experience in this area, right? So I'm just some Joe Schmo who likes reading legal stuff over the internet, right? So just moving along. So this appellate brief is basically written by Thomas A. Frenella, and I'm pretty sure I'm butchering the guy's name, so I apologize. But if you want to get a copy of this bail memorandum, you can actually go to his Twitter page because that's where I got it from. So definitely leave your questions and comments below and let me know if I'm butchering this guy's name. Also, let's see here. So I'm not going to cover every single detail in this appellate brief. I'm just going to skim over the highlights. And with that said, the basic arguments are: number one, the district court clearly erred in denying Mr. Kelly's temporary release because he is eligible under 3142. Now, for those of you who don't know or are watching this video or one of my videos for the first time, I've actually covered most of the federal statutes involving R. Kelly's case. And I'm pretty sure that if you go to my YouTube page and then you do a search for either R. Kelly bail denial or R. Kelly bail, you'll find a detailed video that explains 3142, right? So I'm not going to go over that in this video. Check out my YouTube page, right? So he's basically saying that, you made a mistake. 3142 says that he should be released, right? So we're going to get into some of the reasons why he say that. And then number two, the second argument is Mr. Kelly continued detention violates his right to counsel and right to assist in his defense, right? So he's essentially saying he can't represent himself. I'm sorry, he's essentially saying that he can't defend himself, not represent himself. He has legal representation, so he's not pro se, but he's essentially saying R. Kelly cannot defend himself because you have him locked up. So you got to let this guy go so he can properly defend himself. And then the third argument, he's saying the district court clearly erred in its finding that Mr. Kelly was a danger to the community and a risk of flight because he met his burden by producing credible evidence that rebutted the government's presumption, right? So that's the third argument. So it's essentially three arguments. The first one, the error in the decision and saying that he was eligible, 3142. The second argument is that he can't defend himself. And then the third argument is focused on the statute, which basically governs whether or not you should let the guy go based on whether or not he's a danger to the community, so on and so forth. And again, regarding 3142, I've already covered that in several videos. Go to my YouTube page, go to my YouTube page and look up R. Kelly and bail denial or R. Kelly bail, and that video is going to pop up for sure, right? So let's just go ahead and move right along. I'm gonna see if I can kind of speed through this. Like I said, I've reviewed this whole brief and I've highlighted some of the sections that I want to go through. So I'm just going to try to get to these sections. So Thomas basically says in our society, liberty is the norm and detention prior to trial or without trial is the carefully limited exception, right? So and he actually provides some case law on why he's saying this. Basically, he's arguing that the norm is to let the guy go, right? And in the R. Kelly situation, you should have let him go. You don't have any evidence that's going to show that he should be locked up, right? So you should essentially just let the guy go, right? And he basically goes on and he just says, this is a simple thought, and basically everybody is presumed innocent until proven guilty. And until you're proven guilty, you should be released so that you can defend yourself in court, right? So just moving right along here. Let me see if I can get to the next section pretty quickly. And then he goes on to say Section 3142 has been used sparingly to prevent defendant's release where, for example, he is suffering from a terminal illness or serious injuries, right? And then he basically goes on to say the district court was plainly wrong. The district court erred by not considering that 3142 I-4 should be applied in Mr. Kelly's case, given the fact that the COVID-19 pandemic had a direct and compelling impact on Mr. Kelly's ability to present a defense, right? So everyone knows that R. Kelly, well, if you've been following the case, right? If you've been following R. Kelly's situation, everyone knows that he's had several medical procedures while he has been locked up. And whether you've been following this case or not, everybody knows that COVID-19 is basically impacting America and the world for the most part as a whole. Now, if you're an individual who has any type of business in the court system, you know that it doesn't really matter what state you're in. There was a period of time where the courts were pretty much at a standstill. And as a matter of fact, most municipalities and most cities, most states were at a complete standstill for a period of time. So obviously that is going to have an impact on your case. So actually in Illinois, we're slowly getting to the point where things are proceeding, and even though it's actually proceeding, even though cases are moving, it's still a situation where you're still hindered. You still can't get the representation, not representation. You still can't get the access that you need to the court system. So I guess what I'm trying to say, the court systems are not 100% accessible, right? If I had to put a percentage on it, I would say you can accessibility is probably about at 55 to 60%, right? So from the argument that Thomas is making, he's basically saying that look, the COVID-19 has basically brought the court system to a complete standstill, and we're now just getting to the point where things are moving along, and because of that, it's having a huge impact on R. Kelly's case, so it should have been considered, right? So But for the most part, in this brief, he's arguing that there's a chance that R. Kelly, could contract COVID-19, and he should have been released based on that. And just moving along. And he goes on to talk about another case. Kennedy determined that even if the defendant did not have a heightened susceptibility to COVID 19, the public health crisis and its impacts on the defendant's ability to present a defense nonetheless satisfies 3142. And again, it's really case law that's just reiterating everything I just said. And it makes sense to let a person out if they have not been found guilty of their crime, because number one, they could get COVID-19, and then number two, they need to prepare for their trial. And the fact that we have COVID-19, even if R. Kelly was out of detention, he would still have complications because of COVID-19, right? Some people can't even, well, there was a period of time where we couldn't even leave our homes. So how in the world are you supposed to, go over evidence, and you're supposed to, have a serious attempt to defend yourself when you can't even go out and meet your lawyer, right? Of course we have Zoom and things of that nature, but we live in a world where people aren't necessarily used to Zoom. And then there could be some physical evidence that you need to go over, right? So all of this to me just makes perfect sense. Moving right along, let's see what else we have here. So moving on to the second argument, he goes on to say, Mr. Kelly continued detention violates his rights to counsel and right to assist in his defense, right? And then he argues the government well knows and understands that Mr. Kelly currently does not have and has not had for a period of many months any meaningful access to his counsel, and cannot under the current circumstances assist in his defense at all, right? So one of the things that I'm going to talk about at the end of this video is that the dates for his trial has been set, right? So for a extended period of time, because of COVID-19 and because he's incarcerated, he hasn't really had the ability to prepare for his case. There's tons of allegations against him. There's tons of evidence that he has to sit down and go over with his lawyers. This case is spanning multiple jurisdictions. There is a lot of work to be done, and you can't reasonably do it when you're sitting in someone's jail cell, so this makes sense to me. Moving right along here. And the third argument, the district court clearly erred in finding that Mr. Kelly was a danger to the community and a risk of flight because he met his burden by producing credible evidence that rebutted the government's presumptions, right? So this is the third argument. And in support of this argument, I think he quotes United States v. Mercedes, and he basically, in that case law, basically goes on to provide, noting in presumption cases, the burden of persuasion remains with the government. So the government has to prove, right? So I think it's flipped, where typically, well, you know what? I'm not even going to get into that. The government has to prove that he should be locked up, so the burden of persuasion is on the government. Then the case law also goes on to provide the defendant bears a limited burden of production to rebut the presumption. The defendant's burden of production is not a heavy one to meet. Rather, any evidence favorable to a defendant that comes within the category listed in 3142, right? 3142G, right? To me, the way I take this argument is that he's basically saying the government has, the burden of proof. R. Kelly simply has to, provide some evidence to rebut it, right? So the weight of proving that he should be locked up is clearly on the government's. It doesn't take much for R. Kelly to prove that he should be released. As we've already read, everybody should be given their day in court. Everyone should be presumed innocent until proven guilty. In this situation, you're locking him up as if you're saying he's already guilty, and basically this shouldn't happen. The government has the burden or the responsibility of providing some bona fide evidence or bona fide case to have R. Kelly detained until the actual trial. And to me, he's basically saying the government hasn't done that. And then he goes on to, to give more details. There are serious questions as to the allegations in the indictment. As a racketeering allegation, it is an abuse of the statute. So I also have a video that goes over the racketeering component of R. Kelly's case. Now, one of the videos is actually in a series. Well, actually, there's a series of videos where I go over the impact that the Tekashi 69 video is going to have in R. Kelly trial. In that video, I go over the charge of racketeering and how it should be taken seriously. But I've also made subsequent videos after that based on the motion that one of R. Kelly's attorneys made, that basically shows you that the racketeering component is basically a farce. So in light of that information that has been given in the motions by one of R. Kelly's lawyers, I'm inclined to agree. I agree 100%. I think the racketeering charge is 100% bogus, and he's making that argument here. It's an abuse of the actual statute. You're really just roping in the racketeering charge in order for you to bring in old, outdated cases or old, outdated allegations. And in the case of Illinois, you're trying to revisit a case that he's already beat under a conspiracy charge, right? So that's not really in the New York indictment. I just wanted to bring it up. It looks like their strategy is to lay charges that's going to allow you to bring in old and irrelevant garbage, right? So to me, like, that's what they're trying to do. And again, the racketeering allegations to me are just bogus. It's just kind of a bridge allegation so that you can bring in these old allegations about the Aaliyah marriage license scandal. You're trying to bring in old sex allegation cases, so on and so forth. And the racketeering charge allows you to do that. Without the racketeering charge, you wouldn't be able to do it, right? So to me, it's just bogus, and he's arguing that essentially it's bogus. Moving right along, he also goes on to say there are a combination of conditions of release that will reasonably assure their appearance and safety, right? He goes on to say the district court erred because it embraced the unfounded belief that Mr. Kelly is a risk to flee and that he would obstruct justice. It must be a serious risk of flight or obstruction, not an ordinary risk. And he quotes the actual statute 3142, right? And then he also provides some case law, United States versus Friedman or Freitman, however you want to pronounce it. Questions, comments below. If there's a better pronunciation for it, then I'm just mucking it up, right? And he goes on to say, as to the former, we have repeatedly pointed out to this court that Mr. Kelly has never missed a court date. So to me, what he's doing, he's basically saying that R. Kelly has always come to court. R. Kelly has always held the belief that he'll have his day in court, and that day in court is going to vindicate him of all these charges. He's basically saying R. Kelly has no motive, no desire to flee, right? And to me, that makes sense, right? That makes sense because, the guy is showing up to court every day, and he's going to, all his hearings, except up until the point where you detain him. And when you detain him, now he can't make it to court because he's not being picked up, he's not being delivered, so on and so forth. Moving right along. He goes on to argue further the government has not presented any evidence that Mr. Kelly has any resources to flee, right? And and then he goes on to say, while the government points out that Mr. Kelly receives approximately 200,000 each quarter in royalties, it fails to take into account that the expenses he still has, including rent on the apartment he would live in if released, the warehouse he must maintain, with all the touring equipment and employees and agents and attorneys who receive a great percentage of each and every dollar he earns. More importantly, the government cannot point to a single individual that would attest to the fact that he has ever expressed any desire to flee. To that end, the government cannot point to a single email or text or message supporting its intent to flee theory. In the event, in any event, I'm sorry, where where could he possibly flee to? He would be he. How would he go unnoticed? He would have no money to survive. So, what this thing is covering, to me, he's basically pointing out, some simple facts. One of the things he didn't mention, and I'm curious to know why he didn't mention it, is that R. Kelly already has several judgments against him. I'm not saying that these necessarily matters, but I'm curious to know if those judgments leaves him with 200K left, or it's 200K before he has to pay those judgments, right? So to me, it seems like it that would have been worth mentioning. But again, this guy's a lawyer. I'm pretty sure he's done his homework. He knows what to say and what not to say. So I just thought it'd be interesting to throw that out there because everyone knows, he has the child support payments that he has to continue to make. He's also lost a judgment as regards to the rent for one of his warehouses. Actually, I guess that's what he's talking about. With the studio, right? Not the warehouse, right? So he lost a eviction hearing where the landlord is saying that R. Kelly owes X amount of money, so he has to pay that, right? So I'm not sure if he's done paying that or not. So just throwing it out there. It just seems like an interesting thing to note if it's not paid, right? But at the end of the day, he gets 200K each quarter. So what? Just like anybody else, he has bills, and God only knows what he's left with after he pays that bill, right? So in this situation, we really don't know. But the average everyday American Joe, after he's paid all his bills, he's lucky if he has 10 to 7% left over, to which he can do whatever he wants to do with it, right? So with R. Kelly, we already know that there's tons of lawsuits being thrown at him every day. One thing that's not mentioned here is the Heather Williams lawsuit, right? Who knows what? I think that actually came out to 50K. I can't remember, but who knows? And who knows what lawsuits are out there lurking, creeping, that he has to deal with on a regular basis. So just because he gets $200 every 200,000K every quarter doesn't say anything, and it doesn't necessarily means that he's going to flee just because he has money. Then he basically goes on to argue Mr. Kelly's past behavior in the present case shows that he is unlikely to obstruct justice. One of the alleged Jane Doe's victims until very recently was Mr. Kelly's girlfriend, although completely out of the norm. And even though she was an alleged victim, she was regularly allowed to visit Mr. Kelly while he was in jail at the MCC Chicago and to regularly correspond with him, right? So this is basically going to the allegations of obstruction of justice. And everyone knows that this is more likely Azriel. She was his girlfriend. And basically, while she was going back and forth visited him, she was also a Jane Doe in the the indictment, right? And basically, it goes on to say that while Mr. Kelly knew that she was one of the Jane Does, he never did a single obstructing thing. Given that she is now cooperating with the government, one would think that if there was any evidence of obstruction, the government would cite to it, and it is not. It's never happened, right? So that's a really good point. If you're claiming that he's going to be an obstruction to justice, then obviously during the time period that she was going back and forth to visit R. Kelly in prison, one would think that if there was evidence of obstruction of justice, the government would present it to argue that he should be detained, because she's now a government witness, right? And the government hasn't presented anything, right? So we have to assume that there was no obstruction of justice, right? So frankly, the idea that Mr. Kelly would now obstruct justice I'm sorry. Frankly, the idea that Mr. Kelly would now obstruct anyone is folly. The government has disclosed little evidence revealing the substance. The government has disclosed little evidence revealing the substance of its case, but what is known is that the individuals are cooperating with the government and have had absolutely no contact with Mr. Kelly or anyone associated with him. And lastly, he argues it should be noted that the two co-defendants in the Northern District of Illinois, including the supposed mastermind of the obstruction of justice, were both released on bail, right? Without objection, right? So that's actually pretty interesting. Now, I'm going to assume right here that they are talking about Daryl McDavid, right? That's one of the people that I'm going to assume that he's talking about. I'm not sure that's who he's talking about. I have no way of knowing that's who he's talking about. He should have mentioned them in, this motion, right? So I wouldn't have to speculate. But it's interesting. If Daryl McDavid has been let go and there was no objection, then why not let R. Kelly go, right? Because when you look at the the indictment in Illinois, you can see that they're alleging that Daryl McDavid actually did a quite a bit of work in terms of obstructing justice, at least according to the allegations of the government, right? Of course, I don't know if he did any of that stuff or not, right? But they're alleging that he did, right? So you're alleging that this guy basically facilitated the purchasing of child pornography on behalf of R. Kelly. Why would you let him go? Right? So, this leads me to basically speculate that there could be a chance that Daryl McDavid is going to flip. Maybe this is just something that they're holding and they're trying not to reveal, and it'll be revealed at the last minute when Daryl McDavid comes in and testifies. And as a matter of fact, I think I mentioned this and some of the early R. Kelly videos that I've done. I think there's a section on, or there's actually a video where I discuss on 8 reasons R. Kelly can beat his trial, or how R. Kelly can beat his trial. I can't remember the exact title of the video, but in it, I mentioned that he has to deal with people flipping. And to me, it seems like Daryl McDavid could be someone who could possibly flip. Questions and comments below, and let me know what you think about Daryl McDavid flipping. And the reason I say he could flip is because he has everything to gain and a lot to lose, right? So if he testifies against R. Kelly, the government more than likely could cut him a deal where he can completely walk free. Conversely, if he fights it, then he risks going down alongside R. Kelly, right? And I have no idea of how Daryl McDavid could beat his charges. I think most of the videos that I've covered up to this point has been the perspective from R. Kelly. So how Daryl McDavid could actually beat some of the charges in the Northern District of Illinois escapes me, right? But if you have some ideas on that, definitely leave your question comments below. Let me know how you think Daryl McDavid could fight his case in the Northern District of Illinois. So for the most part, that's pretty much it for this video. And I guess we should talk about R. Kelly's trial date in New York.